Hey, hi, I'm Howard Williams with Apple College of Real Estate. I'm the head instructor, CE coordinator here. We're going to talk about Chapter 6 and principles, contract law. I need to start off by saying we're not just talking about real estate contracts, we're really talking about contracts in general. Although we will talk a little bit about real estate contracts, but I want you to think about it just in general. I guess you got to figure out what a contract is. It's a legal enforceable agreement to do some specific thing. What people may not understand is you can have a contract where I don't want you to do something, and that's called forbear. So a contract to do something, or I can contract not to do something. Now, I need you to take contracts seriously because as we talk about contracts, if there's any issue, a court will have to make the decision. So as we talk about this, what would a court say? What would a court say to somebody not do what they say, default the contract? What would the court say? That's what a contract is. Contracts can be created three ways. Orally, you can have an oral agreement, but our best way to do anything in real estate, the best way to do anything is to do it in writing. Contracts can either also be implied by our actions. And what I mean by that, if you go to a restaurant, when you order food, by you ordering the food, by your actions of ordering food, is implying that you're going to pay for it. By your actions. Now, if there's just three ways to keep it, what happens if you don't do one or the other? Suppose you write one thing and do another. Which one to take precedence? What I wrote or what I did? I said I'm putting in writing I would not drive your car, but next thing you know, I'm outside driving your car. So what I wrote was what I did. When I said I wasn't going to drive your car, I said I wasn't going to drive your car. I wrote I wasn't going to drive your car. Then I got in your car. Those are when there's problems. Because in the ideal world, what you say orally, you should put in writing. And what you put in writing, you should do. When all those three things are done, then you have a good contract. It's when you don't do all those things. Remember, everything we do in real estate, we do in writing. Contracts can be unilateral or bilateral. We know uni means one. We know bi means two. A unilateral contract is one person making a promise, like a reward poster. If you find my dog Fluffy, I'll give you $50. That doesn't mean you have to find Fluffy. But if you do find Fluffy, then I have to give you $50. So that's a unilateral contract. And a bilateral contract is two parties making promises. A normal purchase, the seller says she'll sell, the buyer says he'll buy. That's a bilateral contract. So that's two people making promises, uni and bi. Contracts are in the executory phase or executed phase. When I think of executory, I think like running your race. The running the race is the executory phase. When you cross the finish line, you execute it. In a purchase, when you start looking for a house, get your loan, the appraisal's done, title search is done, all that's executory. When you leave the closing table, you execute it. So executory is the process of completion. Executed is completed. A statute, as we said earlier chapters, is a law. The definition of fraud is intentional misrepresentation. So, if fraud is intentional misrepresentation, and a statute is a law, then the definition of statute of law must be laws that deal with intentional misrepresentation. But what the statute of fraud says in contracts, all contracts for sale of land, I'm talking about land, or any interest exceeding a year or more, must be in writing to be enforceable. So you'll find that leases you can have a verbal lease for a year or less, and the courts will get involved. But if that lease is for over a year, it must be in writing if you want the courts to get involved. It's not to say that two people can't have their own agreement, but the idea is, do you want the court to get involved? Is the idea and the thought behind it. So your text talks about valid, void, voidable, unenforceable. So I need to make sure we understand what a valid contract is. A valid contract is a legal contract. And meaning if you took it in front of the court would make the people do what they say they're going to do. That's a valid contract. A void contract is illegal. In essence, the court saying the contract does not exist, so we, the courts, will not get involved in it because it's illegal. Example is that I want to rent a warehouse from you to sell drugs, and I don't pay you the rent. You want to take me to court and make me pay you the rent. So the court will say, I'm not getting involved in this for the drugs because your contract was illegal. So we, the court, will not get involved in the lease. Now they may get involved with us doing the drug thing, but not the lease. A voidable contract is a legal contract, but either one or both parties may void it. They have a choice. So when you think of voidable, you think that someone has a choice to do it. An example was contracts with minors. Contracts with minors are voidable by the minor while the minor is still a minor. It's voidable when the minor hits a certain age. So they're voidable. The only time an adult can void a contract with a minor is if the adult didn't know the minor was a minor. An unenforceable contract is a legal contract, but because of one of the terms that the parties agreed to, one of the parties can't do it, and their reason that they can't do it, the court says is a good reason. So it's unenforceable. Unenforceable example of that is I'm buying your house, but I say I put in the contract that your house has to appraise for $300,000. I put that in the contract. Your house has to appraise for $300,000. The appraisal is done, and your house, the appraisal comes back $295. Well, the court will say, we can't make Howard buy that house. But nothing was wrong with our contract. There's terms in the contract that couldn't be performed, and it was neither one of us our faults. Legally competent contracts, legally valid, and hence binding and enforceable again, if the court won't get involved. Legal competent parties, as I already said to you, contracts with minors are voidable by the minor while the minor is still a minor, and voidable to a certain point when the minor becomes an adult. The only time an adult can void a contract with a minor is if the adult didn't know the minor was a minor. The competent parties. Now, also, legally competent party, it may not just be a minor. It could be someone who's let's say, a senior citizen, and that they don't understand the contract they're getting in. So that may also be an issue, right? Intoxicated people. Contracts with intoxicated people, you have to say to yourself, do they have a choice to buy it? And the answer is yes. So contracts with intoxicated people are voidable because they have a choice. So let's say the lady on the right, while she was there, she signed a contract to sell her house. The next morning, the agent shows up in the sign in the yard, and she says she doesn't remember the agent. She has a choice. She can say, well, I know I was a little tipsy, but I still want to sell it. So she has a choice. Or she may not. They can't agree, you got to go to court. Unsound minds. If you've been declared incompetent, you are always incompetent until someone says you're not. If you've already been declared incompetent, you are incompetent until someone said unsound mind. Persons of unsound mind are of unsound mind and declared incompetent are incompetent until someone says they're no longer incompetent. So if you was declared incompetent 10 years ago and nobody has made any changes, you're still incompetent today. Those are unsound mind. Other instances, the court may say, what was your condition when you entered into the contract? Your text talks about where you loose it, meaning that you understand the contract when you enter in it, then that contract is still be valid. In a purchase contract, we have what we call an offer and acceptance. An offer is when how it works is when the seller puts their house on the market, They put it in the MLS and they're offering their house for sale. So they say something like, I want $300,000 for my house and washer, dryer, refrigerator, garbage disposal, many lines, window treatments, et cetera, et cetera. Then the buyer goes sees it, and the buyer decides that's the house they want. So now the buyer becomes the offerer. When the seller put it in the MLS, the seller was the offerer. When the buyer writes the contract, the buyer is the offerer. The person who's receiving the contract is the offeree. Contract is called offer. Person making the offer, offerer. Person who's getting the offer, offeree. If the contract is signed without any changes at all, then it's what we call ratified, or ratification. Meaning no changes, not even small changes. Like the date, you change one day, it's March 15th, and you change it to March 16th, then it's not ratified. You have to sign it as written. If you make any changes to the offer, it's called a counteroffer. And the person who's making a counteroffer is the offerer, and the person receiving a counteroffer is the offeree. So they go back and forth until they agree, and at that point they become ratified. When the contract is ratified, you must notify the other party that is ratified. When the contract finally gets ratified, you must notify the other party that the contract is ratified. Because it's not ratified until you let them know, delivery. The other thing, any offer can be withdrawn prior to acceptance. Any offer can be withdrawn prior to acceptance. So if I give you a contract and you hold on it for 5 days, I can call you up in 3 days and say, look, we withdraw our offer. It's taking too long. So that's the main thing I want to talk to you about that chapter in 6. A lot of other stuff the contract talks about, someone under duress or menace. The thought is you can't put pressure, undue pressure on someone to make them sign a contract. Cannot. A couple of things. A written contract supersedes an oral one. So if you write something, if you say one thing and write another, what you wrote counts. If you got pre-printed forms and you write something or type something, and what you wrote or type takes precedence. Most contracts are discharged by full performance, meaning the parties do what they say. In truth, you can assign a contract, meaning I can take my contract and give with someone and give it to you. If all the parties agree, we can do that. Other thing I want to talk about is the Uniform Vendor Purchase Risk Act. Says that if neither possession nor title has passed, and there's material destruction to the property, the seller can enforce the contract, and the purchaser is entitled to his money back. Meaning that before we close, the house blows up, you can't make the buyer buy it. If you breach the contract, meaning you don't do what you said, the person who was breached has 6 alternatives. 1, they can accept partial performance, meaning let's say in the contract you said you were going to replace the carpet, but all you did was actually clean it. And I can say your cleaning is sufficient, and I accept partial performance. Or I can say that since you didn't do what you didn't do, I'm not going to do what I said I was going to do, and that's unilateral rescind the contract. If you default me, I can sue you for money damages. Also, I can ask a court to make you sue for specific performance. I can have ask a court to make you do what you said you was going to do. That's called lawsuit for specific performance. Judge, she said she was going to replace the carpet. I still want the house. Make her replace the carpet. That's what you can do. There can be also liquidated damages. Talk about the earnest money part, earnest money. So the defaulting party has a couple options. Statute of limitations mean that you have a certain period of time or the courts will not help you. And that period of time varies from state to state. So that'll be 1-800-LAWYER, right? So again, just a few things I wanted to touch with on this chapter. And have a good evening. Bye-bye.